The Honorables, the presiding judge and judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court.
Good morning. Thank you, Mr. Clerk. Welcome everyone to this virtual session of the North Carolina Court of Appeals. We have one argument for this session today, Short versus Circus Holdings et al. I'm Judge Bryant. Also with me is Judge Rich Dietz and Judge Toby Hampson. We are your panel for today, and we are ready to hear from the appellant.
Good morning, Your Honors, and may it please the court. My name is John Ong, and I am here, as you know, on behalf of each of the listed defendants, all of whom are appellants in connection with this case today. I'd also like to start by reserving 6 minutes of rebuttal time. Your Honors, I would like to begin by simply indicating that we're here today on the motion or our appeal of the court's denial of our motion to compel arbitration. And as you know, in North Carolina, arbitration is favored by the courts, and the public policy is in favor of finding arbitration when it is due and proper. The issue here is not the enforceability of the arbitration agreement itself or its terms. It's simply whether there was an agreement among the parties to enter into the arbitration agreement. The arbitration terms were never challenged. Here today, the discussion is really focused on the fact that at the trial court level, when our motion was heard, the Superior Court judge listened to the argument, but immediately, actually prior to the argument really commencing, announced that the decision was going to be based essentially entirely on whether or not Mr. Short signed the agreement without consideration of any of the issues of agency, which are central, as you see from the appeal. I'd like to just briefly go through some of the facts in this case in order to make sure that all of you have a comfort level with what transpired. First, the Sky Zone facility in Asheville is a facility that includes a number of attractions and amusements, if you will, trampolines, climbing walls, and other facilities. It is, according to the affidavit of Travis Fowler, which was provided to the court in connection with our original motion, Sky Zone and collectively all of the defendants put together a significant effort to make sure that the participants of those attractions were aware of the potential risks and also agreed to a participation agreement, which included an arbitration provision. It's also interesting to know, I'm looking at the affidavit of Mr. Fowler in detail, how many steps Sky Zone took in order to make sure that participants were aware of the agreement and had signed it or made sure that it was signed. That affidavit I won't review by paragraph with you because you've each had the opportunity to see it, but it is worth noting that prior to, actually at the facility itself, there were two areas, if you will. One was sort of an entrance area where participants were asked before they became participants. In other words, people walking in were immediately asked whether they had signed an online form or whether they still needed to sign the form. That process of sifting through people who had or hadn't signed the agreement took place before anyone was then allowed to proceed into the actual area of amusements or attractions.
Actually, if I can jump in here, because that seems to me, that issue appears to me one of the inflection points in this case, is that whereas the affidavit on behalf of your client says these are the processes we follow when somebody checks in. The evidence here is that in this case, those processes may not have been followed, in that Mr. Short apparently went in a different direction from his wife, who was the one who actually kind of completed the check-in process. So talk to me about that. That seems somewhat central to the trial court's decision here, that there was never any, meeting of the minds.
Actually, that's an excellent question. I appreciate you raising that. I actually think that on balance, first, the trial court did not make specific findings about which procedures were in place and which ones weren't. The affidavit of Mr. Fowler was not challenged in any respect by the court. It was simply indicated that it was part of the record. But what is clear from the affidavits, including those specifically of the shorts, which I think really directly answer your question, is both of them acknowledged that upon entry, the manager of Sky Zone specifically asked of them whether the online form had been filled out and whether they had paid. And Mrs. Short, according to the trial court, in the presence of her husband, acknowledged that she had signed up for them online and paid for the tickets, which then she was then asked for people who had done that to then follow up with the remaining process of the check-in. Mr. Short allowed her, he was there, the trial court and his affidavit indicate he was present when that question and her affirmative response were given. She then went off to complete the process, not only for herself, but for her children and for her husband, with his knowledge that she was completing the process. So in fact, the Sky Zone process as outlined was followed. Only after she completed the process for her entire family was the family allowed to go through and in. So to answer your question, it was followed. And that's central to this case because the process was that after the initial question was asked about whether the process had started online, Mr. Short was then aware there had been a process online, was aware his wife had started that process for him, was aware she then went and completed the process for him, was aware she had paid for him, and then he chose to accept the benefits of all of those actions and went through. It's also worth noting that the trial court noted or adopted the affidavit, if you will, wherein the affidavit reflected a whole series of signs and warnings, including repeated ones about whether the waiver and the agreement had been signed. That was part and parcel of what the process was and what was physically in place. Now, Mr. Short doesn't.
In your view, the things you just described there, in your view, are those just undisputed facts that we have to take the version that you just described, or are those inferences that are being drawn from events, and there could be other reasonable inferences that could be made there? What's your view on that?
I think actually the vast majority of everything I just said was actually factually based on the Short's affidavit, with one exception, and that is the presence of the signs. Mr. Fowler testified through his affidavit to their existence. There are photographs in the record to their existence, and Mr. Short's recollection is he didn't recall. So I think that the evidence is in the record that they were present. There is a disagreement of the parties, perhaps, if you were to infer that by not recalling meant that they weren't there. So at most, there would be a question of fact, but I don't think it's actually just an inference. I'd like to, if I could, turn to the fact that the trial court, and one of the central issues in this case of concern is, and with all deference to the trial court, before I even began my argument, the court asked the plaintiff's counsel about the matter, and which was obviously the court's discretion. And the court almost immediately said, yeah, I've read all that. And what it boils down to, correct me if I'm wrong, it boils down to whether or not Mr. Short signed the arbitration. Answer by plaintiff's counsel, yes, sir. Court went on. If he signed it, okay, he's subject to arbitration. If he didn't sign it, he's not subject to arbitration. No matter how many.
Right there in that recitation of facts.
Excuse me, Your Honor?
Mr. Hall, I just wanted to ask you a question about those facts and some of what the trial court said and did.
Yes,
This case has Charles Short as the only plaintiff. Is that correct?
that is correct, Your Honor.
The wife is not a plaintiff
That is correct, Your Honor.
and was theoretically then subject to arbitration based on what she signed. Is that correct?
Yes, the issue is whether she signed as his agent, actual or apparent, because initially the defense didn't know.
No issue that she signed. There's no issue that she signed for herself. It's only whether she signed on behalf of Mr. Short, correct?
Actually, there's nothing in the record about whether she signed one on her own for her own, because I think that the record reflects that she did not intend to participate. She signed on behalf of her husband and her children, although the online form did not indicate that she was signing. It indicated he was signing and required the introduction of personal information, date of birth, I believe it was, as well as an email address, phone, that sort of thing. Does that answer your question, Your Honor?
Yes, actually it does. Thank you.
So
just to follow up on Judge Bryan's question, because I think the follow-up then is well, let me start with this. What's our standard of review? Would you agree that it's de novo for us right now?
I believe it is de novo. I think that there is, and we've indicated that in our brief. And for what it's worth, just in order to make sure I'm handling this appropriately, we're not waiving any issues raised in the brief, even if they're not raised in argument today. But to answer your question, I do believe it's de novo. I believe that if there are cases that suggest that if there is competent evidence to support the trial court's findings, that's what the court needs to look at. And actually what's central here is the court failed to have any findings on the central issue of agency. So
okay, well, that's where I was headed is if it's de novo review and a trial court comes in and says, this is what I'm thinking about the law, and does something, doesn't matter because on de novo review, we just apply the law. So it seems like the real heart of the issue for you is, were there unresolved facts that we can't resolve as an appellate court, only the trial court can resolve, and therefore there's error here? Or applying the undisputed facts, do you win? It's one of those two things. And what the trial court was thinking in terms of legal reasoning is now irrelevant. Do you agree with that?
I think that, let me try and answer it this way. Yes, I think there was error in not actually making a finding or even an indication that agency was considered. Yes, I think that the record reflects sufficient facts upon which the trial court, or in this case, the appellate court, could reverse and find agency. And yes, I think that a court could look at this record and think there are questions that need a factual determination, and that could be a consistent ruling as well, and require that this be remanded for an evidentiary hearing on the issue of agency. I think all three of those are true, if that makes sense. I think the only thing that isn't true is that there is a insufficiency in the record for agency to have been addressed as a matter of required law. And I don't think there's any basis for determination that there was no agency based on the record. I think that it is consistent with all of the agency cases out there that if a principal is aware of an agent having done an action for them or authorizing that action, and then accepts the benefits of that action, then there is agency. And there's no question in this case but the fact that Mr. Short, even if he didn't know before he got to Sky Zone, was apprised of the requirement of the documentation process being completed, of the fact that it had not yet been fully completed, of the fact that his wife went and completed it for him as found by the trial court, that all of that was required for entrance into the areas of attraction. And then he took the benefit of going through. All of that is part of the record. I think questions of fact. Yes.
A question about the pleadings.
Yes, sir.
With respect to agency, and I believe your opposing counsel indicated that the defendants did not allege agency in their pleadings. Is that correct?
So at the time,
does that affect our ability to review that issue?
I don't believe
That the trial court didn't?
No, Your Honor, I don't believe so at all. I think that the basis for the pleadings was the fact that when the pleadings were filed, the documentation reflected that Mr. Short had signed the participation agreement, and that was the information upon which the parties proceeded. The affidavits reflect, in fact, that Mrs. Short apparently signed for Mr. Short, something that Sky Zone would have had no way of understanding based on the documentation. So I don't believe agency is required in that sense to have been pled. I do believe that the factual information related to agency was raised, was addressed in argument, but the trial court did not elect to proceed on that issue. There was no indication from plaintiff's counsel in opposition to the arguments of agency whatsoever. The central question became the fact that the trial court elected to proceed on whether or not Mr. Short signed it as the sole issue rather than really the first issue. What I'd like also to address in this case is the fact that that there are throughout the case law repeated and consistent findings that the principal need not have read the document signed by the agent, and no information required that the agent fully signed and understood the terms of the agreement. I think that the case law is interesting in regard to, for instance, the Heiderbader case that we included in the materials, where a minor working on the Fortnite game filled out an arbitration agreement that was then found to be binding on his father, with apparently no indication that he had read it. The other thing I think that's of interest here is the fact that there is room. I do want to make it clear, we've never contended that agency exists solely as a result of the fact that Mr. and Mrs. Short were married at that time and presumably are today. Agency is not premised solely on their being married, but the case law does suggest that various facts taken together can be assessed in order to determine whether or not there may have been agency. And I do think it's interesting to note that Mrs. Short filled out this documentation, at least the initial documentation, according to her affidavit, without having conferred with her husband, leaving open the question about whether Mrs. Short thought that she generally had the ability to do things for her husband. Something that was a fair inference, back to Judge Dietz's question, I believe it was, about when, what inferences might be drawn here. Maybe that was Judge Hampton, I apologize. An inference may be that based on the conduct of her comfort level in signing for him, and then the fact that he didn't object and raise questions when it was evident she had signed something for him, when presented at Sky Zone with that issue, a fair inference may be that she had agency for him, and then he proceeded to allow her to continue that process, the check-in process as identified in the affidavits.
So how do you square that though with the Milan decision?
So that's an important question. In that case, that's Milan versus Duke, if I'm not mistaken. The issue there is the documentation relied upon by the party seeking to compel arbitration was signed after the critical issues had taken place, was signed without the person against whom was trying to be enforced having any awareness of that being signed or even the process of it having been signed, which is quite factually distinct from this circumstance where Mr. Short was aware prior to participating that the check-in process was initiated and then completed by his wife. So I just think they're factually distinct.
But it almost seems like, in a sense, you're and I'm characterizing obviously, but it seems like the argument is that sort of upon showing up at the check-in process and hearing the question and moving on, that Mr. Short sort of ratified the actions of his wife. What evidence is there in the record that Mrs. Short was acting as an authorized agent or parent agent at the time she actually signed his name or filled out the application in his name?
So let me address that in a couple of different ways. First, I think what's important here is that at the time, I'm turning now to the court's order itself. The court indicated that while in the presence of Mr. Short, Mrs. Short, upon arriving at Sky Zone, a Sky Zone employee, this is number 8, asked the group if they had signed up and purchased tickets online. While in the presence of Mr. Short, Mrs. Short responded that she had done so and went with the manager of Sky Zone to the counter against the wall to complete the check-in process for her family. Court went on to find that, number 11, plaintiff Charles Short did not personally pay for his entrance admission, nor did he sign the agreement. Plaintiff Charles Short was aware before he used the Sky Zone facilities that his wife had paid for his admission and completed the check-in process on his behalf and of his children. When one looks at the actual record, including the affidavits, the answer to your question is this. It's not a ratification of a past act. It was a awareness of and an authorization of the completing of the act. Also, there's a question about whether Mrs. Short, in fact, had actual authority and agency in a general sense to fill out basic forms for her husband for this type of thing. She either was committing fraud or she was acting under the impression that she was doing something her husband either had routinely allowed her to do or would expect he would want her to have done. And when they got to Sky Zone, that question essentially was presented to them when the manager himself, according to their affidavits, asked them whether they had signed up online, and she said she had done so. But moving forward, and what's so critical in this case, is that wasn't the end of it. The answer didn't allow them to go through. They needed to have someone complete the check-in process for them all. And she went and did that. And he was aware of that fact. And that is clear agency. And that's unmistakable. And that is how he then managed to get through and accept the benefits as found by repeated case law or courts repeatedly. Did the principal accept the benefits of the action of the agent? And yes, is the answer here without question.
So, counsel, what is the evidence of what Mr. Short understood that check-in process to be? It could have been just sign your name here. It's more, what evidence is there about how much information Mr. Short had about that?
An excellent question. And that perhaps wanders into the realm of a factual finding that was never really made and a legal conclusion that was never sought that was sought, but the court didn't provide us. What is evident from the affidavits and the information in the record is that Mr. Short was aware that the check-in process needed to be completed in order for him to gain admission. And that's what the trial court found. What the actual requirements of that check-in process were can only be parsed from the signs posted throughout the facility, which specifically required the waiver documentation. And Mr. Fowler testified all of those were present. And they're also, all those warnings and information are part of the document Mrs. Short signed for her husband. But the real question then becomes, Mr. Fowler testified that signs such as guest responsibility, everyone that enters a Sky Zone court or activity zone must have completed and signed a valid Sky Zone waiver. Prior to participation, all guests and accompanying adults assume full responsibility that, first one, all waivers are properly executed. So the factual information is that Mr. Short had in front of him ample opportunity to know what the procedures consisted of. The record reflects that the signs were there. The record reflects that he doesn't recall seeing or reading them. I'm happy to answer any further questions at this time, other than I see my time, if I'm reserving for rebuttal, has come to an end. But are there questions while I'm here in front of you at this time? Thank you all.
All right, thank you. We'll hear from the appellee.
May it please the court, good morning. My name is Brian Davis, and I represent the plaintiff appellee, Charles Short. What brings us to the Court of Appeals today are the actions, as some of you have already noted, the actions of the defendants themselves. And I'm not referring to the argument in our brief regarding invited error. Rather, I'm referring to the defendants' failure to follow their own policies and procedures. The affidavit of SkyZone, signed by its general manager, sets out the steps, and there are 6 of them, if you count them, 6 steps that the SkyZone employees were supposed to follow in order to confirm that each and every person who entered the SkyZone to participate had signed what SkyZone calls the participation agreement, release, and assumption of the risk. And this is what has been referred to as the agreement, which also includes the arbitration clause that is at issue here today. Now, the steps that the SkyZone employees were supposed to follow to confirm that each person had signed the agreement were as follows. First, the SkyZone employee was to approach each person as they entered and ask, have you signed the online agreement? The second step, if the person had not signed online before they arrived, then the SkyZone employee was to direct the customer to a computer kiosk where they were to sign the agreement. The third step was the customer completes the agreement on the computer. The fourth step was that the customer takes the receipt from the computer after signing up and goes to the check-in counter. The fifth step was that the customer presents the receipt at the check-in counter and buys a ticket. This is where the customer pays. The sixth step was where the customer gets a sticker in exchange for paying and displays it on their clothing. And then they are allowed to enter the facility. If SkyZone had followed their own policies and procedures, these 6 steps, we would not be here today. The only evidence.
And Mr. Davis, I think the argument though from the counsel for the defendants here is that no, in fact, those steps were followed. They were just followed utilizing Mr. Short's authorized agent. Mrs. Short has been authorized to undertake 2 steps on his behalf, and therefore these processes were followed properly. I mean, do you agree that the trial court's order, either in its findings or its conclusions, simply do not address that issue of agency or actual work?
I would agree that there is nothing in the trial court's order regarding agency, but the issue of agency was argued in the memorandums of law in support of the defendant's motion and in the plaintiff's memorandum of law opposing the motion to compel arbitration at the trial court level. Argued in both of those memos. It was also argued by the defendants at the hearing before the trial court, and the trial court decided that that was not an issue, that was no issue of agency. So the trial court considered those arguments and in its discretion did not include findings of agency because it found no agency. A trial court is not required to include in the order things that it did not find.
So, counsel, let me just jump in. I think that's right. So I think the heart of this case is the suggestion, though, that this issue has to be resolved as a matter of law. And if there are disputed facts that are necessary in order to resolve the agency question, and the trial court did not resolve those facts, which it would need to do, that our only recourse is to send it back because we don't find facts here. So we can only review, on de novo review, we can only review the law. So we heard from your friend for the defendants an argument that there are unresolved facts that are key to answering the question of whether there was agency here. So what's your response to that?
Our response is that the defendants invited this error because the defendants, as you would note and can note from our supplemental filing to the record, the defendants actually submitted the order that was actually signed by the trial judge. When I draft, as the party who won at the trial court level, the judge instructed me to draft the order. I always send it to opposing counsel, which I did. And in my proposed order, there were findings of fact on the issue of agency. And that proposed order is also in the record. Opposing counsel refused to sign the proposed order that I sent him, and in fact, submitted his own order to the court, which is the order that the judge signed. Opposing counsel did not include any finding of fact or conclusion of law on the issue of agency in its proposed order, again, which the court ultimately signed, and which is an issue here. So now,
counsel, one thing that troubles me a little bit about this argument I wanted to ask you about is certainly when you're representing your clients, you are advocates. And I realize in North Carolina, we do something a bit that some lawyers from other states or other jurisdictions find strange, which is lawyers for parties routinely draft orders for judges in North Carolina State Court. But when they're doing that, aren't we sort of treating it as if they're acting as officers of the court, providing this information that's ultimately going to be the trial court's order, and they're no longer an advocate for one side? And if that's true, then I don't know if we can apply something like the invited error doctrine, because that applies to an advocate who advocates for one position and then the court accepts it and then tries to change. So what's your response to that?
well, I think that in drafting an order, you include what was considered at the hearing. And if you argued that there was agency and the court instructs you to, and the court did instruct me to include everything that was argued in the order, you would include that there was no agency. In other words, that Mr. Short did not know, was not aware that his wife had signed up online, was not aware that she had included his biographical information, and then that he was not aware after the fact, once they got to Sky Zone, that she had done these things. So I understand what Your Honor is saying, and I agree that we act as officers of the court when we're arguing in front of the judge. Even though we're being advocates, we can't misrepresent something to the court. So does that answer Your Honor's question?
It does, thank you. But I think you can see where I'm headed here, which is typically as appellate judges on de novo review, if we receive a decision from a trial court and conclude that there's disputed questions of fact, we just send it back and say, make findings, resolve these fact questions, as we don't find facts at the appellate level, and then we can engage in a meaningful appellate review of the legal question. And I'm not aware of any precedent, so please inform me if there is any. It says, well, but in a draft order proposed on one side or the other, those findings weren't there, so invited error on behalf of one of the parties. I've never seen that before.
I think Your Honor is correct. I'm not aware of any appellate precedents on that issue either. But I believe I really think there's a question about what the standard of review is here for the court. And I know the defendants are arguing that it's de novo, but, in a dispute about whether there is an agreement to arbitrate, the trial judge decides whether an agreement exists. And the party seeking arbitration, as everyone knows, has the burden of proof to show that the parties mutually agreed that there was a meeting of the minds to the agreement. And the trial judge's findings regarding the existence of that agreement, whether there was an agreement or not, are conclusive on appeal, as long as there is competent evidence to show that the judge ruled based on the evidence. And that's even when the evidence might have supported a different finding. So, the fact that the defendants argue that agency should have been in the order, the trial judge is free to decide there's no issue of agency here. There was no agency here, and there is no requirement that the judge put that in the order. Now, and I want to just, talk about the issue about whether or not there was an agreement here. The agreement to arbitrate, an agreement to arbitrate requires basically two things: a mutual agreement and a meeting of the minds between the parties. And I wanted to just mention the opinion by Judge Bryant in the Sciolino versus T.D. Waterhouse case, where this court, where Judge Bryant noted that this court has even suggested that an agreement to arbitrate, if contained in a contract covering other topics, must be independently negotiated. And then, and this requirement for, or apparent requirement for independent negotiation underscores the importance of an arbitration provision and militates against its inclusion in contracts of adhesion, where there is no negotiation.
That actually takes me to sort of a factual question that jumped out at me in reviewing the record. In reviewing the electronic printout of the registration agreement, it appears there were places in different points, including the arbitration clause, where there needed to be a check mark made so that the person registering, it wasn't just one big form agreement, I accept. There appeared to be spots where the person registering was required to check specific boxes agreeing to these specific terms. Is that an accurate view of the record?
It is, in my view, Your Honor. I saw that as well. That was also argued by, I believe, defense counsel at the trial court level, that the box had been checked. But, I think the suggestion is, in the Sciolino case, is that when an arbitration provision is included in an agreement, there has to be independent negotiation, especially in contracts of adhesion, which is what this is. This was not an arm's length agreement. There was no negotiation about the terms or the provisions. It was sign this agreement, pay your money, and go jump. It's a contract of adhesion. The bargaining power between a multinational conglomerate versus an individual is a contract of adhesion. So I think that, the issue that the trial court focused on, which is whether there was an agreement or not, whether there was a meeting of the minds, is the correct issue. And the trial court found, based on the affidavits submitted, that there was no meeting of the minds. There was no mutual agreement. Now, getting to the issue of agency, the defendants say that the order is defective because there are no findings of fact or conclusions of law on the issue of agency. But, again, as I think Judge Bryant pointed out, the issue of agency was not raised in any of the pleadings, nor was the issue of ratification which is an affirmative defense, which is waived if you don't plead it. The defendants did not plead ratification in their answer as an affirmative defense.
To be fair, counsel, wouldn't that be ratification as an affirmative defense to a contract claim? And this is not a contract suit. It's a collateral question of whether or not there's an agreement to arbitrate. I've never seen a requirement that you have to include conceivable defenses to an argument that the arbitration agreement is invalid as part of a responsive pleading to an affirmative claim like a tort claim. Do you have any precedent on that?
No, Your Honor, I do not. And you may well be correct on that. I'm not sure.
Well, can I move you to sort of what I think your stronger argument, where I'd like to try to figure out what's going on. So can you tell me, we're looking at this as under de novo review. So we're assuming essentially that the trial court considered agency and rejected it, but that doesn't really matter because we have to look at it on our own now. And so we're trying to look at this record and say, can we as a matter of law say no apparent authority here? So point me to the facts where we can look at this record and say, yeah, we can conclude that as a matter of law. We definitely don't need any more facts from the trial court. It's in the record already.
Yes, sir. So I think to do that, we've got to go back to when this group of 26 people entered the Sky Zone, as is set out in Mrs. Short's affidavit. I believe there were, I think there were 12 adults and 14 children entering this common area at Sky Zone. And they're approached by the manager who says, did y'all sign up online? And several of the adults raise their hand. And he says, well, you guys follow me. And then another employee says, all right, the rest of you, which includes Mr. Short, y'all follow me to the area where we're going to take off the shoes and socks. So what we have to, at that moment, look at is what was Mr. Short's manifestation of authority to his wife? Was he making a manifestation that you have my authority to go and act on my behalf, to contract away my constitutional right to a jury trial and enforce an arbitration agreement? We're talking about a very significant right. So, that's the factual issue. And, there is no evidence that he made a manifestation, that she had his authority to go and do that. What was supposed to happen based on the affidavits is that the employee, the non-management employee was supposed to say, okay, well, the rest of you adults go to the computer kiosk and sign the waiver, sign the agreement. That didn't happen. So, there was no reasonable and justified reliance by Sky Zone that Mr. Short had manifested his authority to his wife to go and contract away my rights. I think that's the issue here. And I think the facts were before the trial court and are before this court are sufficient to say there was no apparent authority because there was no manifestation by Mr. Short. You can't look at the agent's conduct and derive whether that is apparent authority. An agent can say anything they want to. You have to look at the principal or the alleged principal and say, well, what did the principal do? What did the principal know? How did the principal act? And the only facts are that Mr. Short did what he was told. He followed the employee and herded the children over to remove the shoes and socks. And then the wife came and gave them the socks and they went and jumped. Those are the facts that are in the record. And I think it's a stretch to say we can look at these facts and say there was apparent agency. I don't think it's a question of fact. I think it's clear. As a matter of law, there was no apparent agency. On the issue of agency, when a husband and wife is at issue, agency can be shown either by direct evidence or by evidence of such facts and circumstances as will authorize a reasonable and logical inference that the wife was empowered to act for the husband. There is no reasonable inference to be drawn here based on the conduct of Mr. Short. He didn't say, yeah, she's got my authority to sign that, or he didn't respond to an employee who said, did you sign up? And he's like, she's doing that for me. There's absolutely no evidence about that in the record. I don't think there is any way this court can say as a matter of law that there's, let me try it again. I don't think there are issues of fact to be ruled upon or decided upon on the issue of agency.
Right. I think another way to phrase that is say, it was not your responsibility to ensure that the record included facts that could be in the record that would show the apparent authority. And so if we're just looking at the cold record and determining what they should, unless there's a fact dispute that we can't resolve, if there just could have been evidence and it's not there, then your client wins. We affirm the trial court. That's your argument.
Yes, sir. And you said it much better than I did. Thank you. Does the court, I have about 7 minutes left. Does the court have any other questions for me? I'm happy to address them.
Any further questions? You're not required to use all the time you have, so we appreciate your brevity. Anything else? If not, we'll hear rebuttal from Mr. Ong.
Your Honor, if I may I make one other point? All right, thank you. Since I do have some more time left.
Don't have to take it. You can make another point.
Thank you. I just want to emphasize again the issue about reasonable reliance by the third party in this situation. The cases in North Carolina say that the third party must exercise reasonable prudence. So what does that mean in this situation? Well, reasonable prudence would mean that Sky Zone, you've got to, if you look at the information in the record, Sky Zone knew that it had an issue with individuals signing their agreement on behalf of others. And we know that because in the agreement itself, it says that, by signing this agreement, I agree to also bind my spouse, my children, my siblings, my cousins, my parents, and it goes on to list a whole host of other people that this person who is signing this agreement is supposedly signing on behalf of. So Sky Zone knew they had an issue with people signing up on behalf of others. So that goes to the issue of what is reasonably prudent for the third party, for Sky Zone. So Sky Zone, because they knew they had an issue with this process of how they had people checking in, had a duty to do a little bit more to make sure that their reliance was reasonable. And in this situation, they should have just followed their procedure and asked every single person, have you signed up and signed up the agreement online? And if you haven't, then you've got to go do it now. So their reliance was not justified. Their reliance was not reasonable or prudent. And Sky Zone also knew that they had a problem with the sign-in process because of one of the cases that we cited in our brief at the trial level and here. And that is the case of the Burns case versus Philly Trampoline Park, because that case put Sky Zone on notice that they had a problem with spouses signing up for their spouse. That issue was almost identical to the issue in this case. One spouse signing the waiver, not telling the other, and then the other getting hurt. So Sky Zone knew as early as 2016 they had a problem with this sign-in process. And then the third thing is that, the defendants knew, based on the facts in the record, that all 12 of the adults in this group did not raise their hand and go to the check-in counter. So they knew there was an issue about whether those folks had signed up or had signed their agreement. And they didn't act reasonably and say, well, hey, wait, you guys who didn't raise your hands, you've got to sign up at the kiosk. So this whole thing of reasonable reliance and reasonable prudence was not done by SkyZone. And with that, I'll pass back to Mr. Hong.
All right, thank you very much, Mr. Hong.
Thank you, Your Honor. I'd like to just briefly touch on a few issues that have been raised. One of them is the Burns case is totally inapplicable for multiple reasons, including the fact we don't have the facts of the Burns case in the record. We have simply the case itself from out of state. The Burns case, the one factual information that we do have is that the husband was not aware and apparently in the bathroom at the time of the execution. There's nothing related to the facts in this case where upon arrival at the facility, there was a discussion about the check-in process and the knowledge that the wife then proceeded to check in. We also don't know if any of the procedures were the same. So it's not applicable. The other issue that's worth noting, and I think Your Honor touched on, is the concept of invited error. I rarely submit, as reflected in the record, by the way, my letter that indicates I rarely submit an alternative order. I did so in this case based on the fact that the transcript of the hearing reflects what happened, and that is that the court made a decision based solely on whether or not Mr. Short signed the document and did not reflect any questioning or commentary, or in his decision whether he considered agency at all. And the proposed order submitted by plaintiff's counsel had all kinds of findings of agency, both factual and legally. Mine did not. Mine did not because it reflected what happened at the hearing. And that's the judge accepted my order. Of course, the judge had the ability to revise or change it in any respect, but my effort was to provide an accurate reflection of what happened at the hearing and not to try and create as an advocate something different than what happened at the hearing. The other thing that's worth noting is the issues of the steps being followed, I think, is actually helpful to the defendants in this case. 6 of the steps, the most important one is the approaching of the person at the entrance as to whether or not they had signed the agreement, which was done, according to plaintiffs, by the manager himself. At some point, going to your question about whether there are facts to be found or inferences to be applied, the fact that SkyZone and the defendants made all these efforts, online sign-in, in-person check-in process, specifically asking about the forms and the check-in, is consistent with efforts to try to make sure everyone complied, consistent with the signs on the wall. Of the 6 steps referenced by plaintiff's counsel, the first was done. The second one didn't apply because Mrs. Short indicated they had signed up. The third one didn't apply because Mrs. Short indicated they had signed up, so there was no need to fill out the online waiver. She had already done so. The next one was a question of the receipt and check-in process. She indicates she went and did the check-in process, and the court found that to be the case with the knowledge that Mr. Short knew she went to do that for him. The next one is whether she paid for a ticket, and the record reflects she did pay, and the court found that she paid for Mr. Short and that he knew she paid for him. And then the last one is a question of a sticker, which is a factual question that the court did not answer. Mr. Fowler's affidavit reflects the process of the sticker needing to be done and how that process unfolded. Mr. Short said he either didn't recall or it didn't happen. That would be a factual finding. That was not made. What is central in this case is that the question of agency, both the facts that support it and the legal conclusions that would have addressed whether it took place as apparent or as actual, were never considered by the trial court, were never included in the order by the trial court. And Bookman 1 and Bookman 2, for shorthand, absolutely make it crystal clear that it is not sufficient for the trial court to make certain findings, such as, in that case, the specific finding after remand that the purported agent didn't have actual authority to sign a particular document. That wasn't enough. The court on remand indicated that the judge had to make specific factual and legal findings, including whether that person, that principal, had authorized the agent for the general check-in process. And I'm paraphrasing, but you all know Bookman 1 and 2. Here, it is true that that was never found by the court. There's an absence in the record. So simply put, we would request that based on, there is no question, there is plenty of evidence to find agency as a matter of law. I request that you, or ask respectfully, that you find agency as a matter of law. If you don't, there is absolutely enough evidence to make it a question of fact for further factual findings that need to be addressed by the trial court, including an evidentiary hearing. So either we ask for a reversal and a finding as a matter of law of agency, or a remand for an evidentiary hearing to address the issue further. And with that, I thank you all.
Thank you very much. We certainly appreciate the arguments of counsel in this case. And with that, that ends this session of court. Mr. Clerk, let us close court at this time.
This session of the North Carolina Court of Appeals is now adjourned.
If counsel, excuse me, if the panel could remain.